Welcome to another online PowerPoint presentation. I am Stephen Teal, Partner and Director of Legal Research at Gardner Roberts. I have been a research lawyer for nearly 30 years. In this presentation, I will be discussing issues related to residential and commercial leasing in the context of the COVID-19 health emergency. Please be advised that this presentation is not intended to be legal advice and should not be relied upon in any way whatsoever as being legal advice. In Ontario, there are two distinct regimes when dealing with leasing issues. There is the residential tenancy regime and there is the commercial tenancy regime. Most residential tenancies fall under the Residential Tenancies Act. This act contains various procedures and notice periods and generally protects tenants. The Commercial Tenancies Act does not apply to residential tenancies whatsoever and contains certain procedures dealing with commercial tenancies. As will be discussed in this presentation, a significant distinction between these two regimes is that in a commercial tenancy, a commercial landlord is not required to obtain a court order to evict a tenant. With respect to residential tenancies in general, once a residential tenant enters into a lease agreement, the tenant has security of tenure. The security of tenure of a residential tenancy is governed by Section 37(1) of the Residential Tenancies Act, which simply provides that a tenancy may only be terminated in accordance with the Act. Accordingly, a residential landlord must obtain an order through the Landlord-Tenant Board to evict a residential tenant and terminate the lease. Under Part 5 of this Act, there are various provisions that deal with providing a tenant with notice of termination. Among other reasons, a residential tenancy can be terminated for the non-payment of rent, illegal use of the rented premises by the tenant, where a landlord needs the leased premises for personal use, or where the leased premises are going to be renovated or demolished. In each case, the length of notice that a landlord must provide to a tenant varies with the reasons for the termination. The COVID-19 health emergency has impacted residential tenancies. Early in the COVID-19 health emergency, the Ontario government made a significant announcement in connection with residential tenancies governed by the Residential Tenancies Act. Premier Doug Ford announced that there would be no residential evictions. The Ontario government quickly implemented Ontario Regulation 73/20, which suspended all limitation periods under government statutes and rules, and essentially ordered a time freeze under all statutes and rules as well. The Landlord-Tenant Board immediately then announced that all hearings related to eviction applications, unless the matter related to an urgent issue such as an illegal act or serious impairment of safety, were suspended, and that eviction orders, again unless the matter related to an urgent issue such as an illegal act or serious impairment of safety, would not be issued. The Sheriff's Office, which is the only office that can enforce a residential tenancy eviction order, was also directed to not enforce any eviction orders. However, the fact that the Landlord-Tenant Board is not in general hearing eviction applications does not mean that a residential tenant can stop paying rent on time. The Ontario government has not granted any order that allows a residential tenant to stop paying rent. Accordingly, residential landlords can still serve tenants with eviction notices if a residential tenant does not pay his or her rent on time. Now, not all residential tenants are protected against eviction. Although the Residential Tenancies Act applies to most residential tenancies, there are exceptions. The exceptions are listed in Section 5 of the Act. So, for example, the Act does not apply to living accommodations that are intended for travelers or vacationers, individuals who work on farms and whose occupation is conditional on continuing to be employed on the farm, and a living accommodation where the tenant is required to share a bathroom or kitchen with the owner's spouse, child, or parent, and where the owner's spouse, child, or parent lives in the building in which the living accommodation is located. There are other exceptions, and the viewer is directed to Section 5 of the Act for the complete list. Now, since the Act does not apply to these accommodations, a landlord is not required to obtain an order from the Landlord-Tenant Board to evict a tenant. This was seen recently in the case where a landlord evicted a nurse who lived at the owner's home where she shared the kitchen with the owner. As a result of the owner's concern about contracting COVID-19, the owner decided to have the nurse evicted from the owner's home because doing so was permissible under Ontario law. Now, there is a case which suggests that even for residential tenants not protected by the Act, that a landlord must give the tenant reasonable notice. The case is Boudreau v. Landry, which was decided in 2013. While this is a small claims court decision, the applicable principle was also applied by Justice Jennings in Ihuha v. Kapla, which was decided in 1994. However, in situations involving the health and safety of an owner or an owner's family, reasonable notice may be no notice whatsoever. The sheriff's office is not required in this kind of case, and thus from a procedural perspective, a landlord can call police to assist in the eviction of a tenant that is not protected by the Act, like a tenant who shares a kitchen or bathroom with an owner. In this kind of situation, a landlord should be careful, however, to ensure that the tenant is able to take their property or that their property is not discarded. Failure to do so could lead to a claim in damages. With respect to commercial tenancies, the Residential Tenancies Act obviously does not apply to commercial tenancies, and therefore any of the notice provisions under that Act have no application to commercial tenancies either. For commercial tenancies, there is a separate statute called the Commercial Tenancies Act, which deals with matters related to those kinds of tenancies. Commercial tenancies are, of course, those that deal with a leasing arrangement between a landlord and a business. In those contracts, the parties generally include terms that deal with the duties and responsibilities of the parties, establish when the lease can be terminated, and the length of any notice. For certain breaches by the tenant, there might be a time given in which the breach can be cured. In general, in a commercial tenancy agreement, one of the grounds that will permit a commercial lease to be terminated is non-payment of rent. The COVID-19 health emergency has, like in the case of residential tenancies, not permitted commercial tenants to avoid their rental payments, and thus the failure to pay rent will cause a breach of the commercial lease. In circumstances where the commercial landlord wants to evict a commercial tenant because of the breach of contract, the landlord can re-enter the premises and change the locks to prevent the tenant from re-entering the leased premises. Where the landlord does so, the landlord will usually follow up by starting a legal action against the tenant for the rent that would have been due for the rest of the lease. By re-entering the premises and changing the locks, the landlord signals that it is accepting a repudiation of the tenant's lease. It is suggested that when a commercial landlord invokes its right of re-entry and changes the locks, that the landlord should do so when the premises are vacant. As well, a notice of termination should be posted in a conspicuous place, and a copy of the notice of termination should be delivered to the tenant or the tenant's lawyer. Usually, the landlord's notice of termination is affixed to the window of the front door of the premises. The landlord should ensure that perishable inventory is properly maintained and that when the tenants ultimately remove their inventory, that their removal is supervised. The commercial landlord has other options as well, including exercising distress against the goods of the commercial tenant. Distress might be a viable option where the landlord does not have any other potential tenants for the leased space and where the tenant has sufficient goods on the premises. Under Section 43 of the Commercial Tenancies Act, distress must be reasonable. As well, the Act provides that a tenant's goods which are not on the premises cannot be distrained for rent. A commercial landlord must be careful in exercising its rights because case law clearly provides that a commercial landlord cannot have both the remedies of forfeiture of the commercial tenancy and distraint at the same time. One of the leading cases in this area of law is the 1972 Ontario Court of Appeal decision in Re Lucier v. Dennison. It is important to note that where a commercial landlord decides to distrain the tenant's property, the distress must be exercised carefully. Under Section 55 of the Commercial Tenancies Act, a landlord who either takes excessive distress or takes distress wrongfully is liable in damages to the owner of the goods distrained. As well, Section 55(2) of this Act specifically makes a landlord liable for damages where it distrains a tenant's goods when no rent is owing. A commercial landlord that wants to exercise the distress should always consult a lawyer before doing so. Now, aside from terminating a lease and re-entering the lease premises and then suing for rent for the remainder of the entire lease, or affirming the lease and exercising distress on the tenant's property, a commercial landlord can also simply affirm the lease and bring a claim for unpaid rent, or affirm the lease, re-enter the premises, and then re-let the lease premises. This latter option is available to those landlords who have reserved a right of re-entry in the lease or received a court order permitting them to this remedy. A leading case in this area of law overall is Highway Properties Limited versus Kelly Douglas, which was decided by the Supreme Court of Canada in 1971. It should be noted as well that in circumstances where a commercial lease does not speak to the issue of repossession for failure to pay rent, a commercial landlord remains entitled to terminate a commercial tenancy and regain possession where there is a failure to pay rent under Section 18 of the Commercial Tenancies Act. Under this provision, rent must be in arrears for at least 15 days. Now, turning to COVID-19 consideration, the COVID-19 health emergency presents some interesting questions that courts might be required to grapple with once they return to normal operations. With the government ordering the shutdown of all non-essential businesses and commercial landlords taking steps to restrict access to office towers or shutting down shopping malls, many tenants have been unable to earn revenue and have been unable to pay rent as a result. Under our law, a tenant who is in default of a commercial lease can make an application to the court for relief from forfeiture, and under this remedy, pursuant to Section 20(1) of the Commercial Tenancies Act, a court is entitled to make an order it thinks fit. A commercial tenant can also fight back and argue that where a landlord has restricted access to the leased premises or closed the premises entirely, the tenant is entitled to an abatement of rent on the grounds that the commercial landlord has breached its covenant of quiet enjoyment. The covenant of quiet enjoyment essentially gives a tenant access to leased premises free from unreasonable interference by the commercial landlord. A commercial lease agreement may also contain a force majeure clause that might impact the rights of the parties. Both commercial landlords and tenants should carefully review their leases to assess whether a force majeure clause exists and how it may apply to the COVID-19 health emergency and whether it applies to the payment of rent. In general, this kind of clause will not relieve a tenant from paying rent. Nevertheless, there are many practical considerations that both commercial landlords and tenants should take into consideration when assessing their respective rights. Although the remedies available to landlords and tenants are well established, the current situation may require both landlords and tenants to work together and discuss creative solutions which will be to the benefit of both parties. Commercial tenants don't want to go out of business, and commercial landlords don't want to maintain empty spaces. Accordingly, commercial parties should consider options like rent deferrals, rent abatements, or make other arrangements. Now, Canadian businesses have been crying out for relief as a result of mandated government shutdowns and requirements that people practice social distancing. The media is filled with stories of businesses, particularly restaurants, that have been required to cease their operations for good. Without the ability to continue to serve patrons, businesses are able to earn any revenue and simply cannot pay rent. Accordingly, to help lessen the impact of COVID-19 on small businesses in particular, on April 16, 2020, Prime Minister Trudeau announced his intention to introduce the Canada Emergency Commercial Rent Assistance Program. Although this program has not yet been legislated into law, the Prime Minister stated that this program would provide loans, including forgivable loans, to commercial property owners for use in lowering or foregoing rent for small businesses for the months of April, May, or June. However, since provinces and territories are responsible for property rights and thus owner and tenant relationships, cooperation from provincial and territorial governments will be required. Thanks for watching this presentation. Remember, this presentation is not intended to be legal advice and does not necessarily represent the views of Gardner Roberts, LLP. You should always consult a lawyer when seeking or needing legal advice.